Usually when we talk about, pouring concrete at a major construction site, there's this expectation of absolute permanence.
Right, yeah, it's literal concrete.
Exactly. The trucks roll in, the foundation is poured, and once that mix cures, it is literally written in stone. You can't
Right.
just change your mind and move the foundation a few inches to the left.
No, absolutely not.
And the legal system has its own version of poured concrete, especially in New York appellate law. Like when a plaintiff wins a summary judgment and then an appellate court looks at that ruling and actually affirms it, that concrete has essentially been reinforced with steel rebar.
Good gavel is banged, it's done.
Right. The case, or at least that specific part of it, is considered permanently closed. But today, we are taking a deep dive into a recently entered appellate decision that proves, well, somebody out there clearly has a
A
jackhammer.
very persistent jackhammer.
Seriously. This is from May 21st, 2026, signed by Susana Molina Rojas, the clerk of the court for the Appellate Division, First Department. The case is DeSouza v. Hudson Yards Construction 2, LLC.
Oh, this one is fascinating.
It really is. The sheer mechanical persistence required to undo an appellate affirmed judgment makes this, just procedural masterclass. Okay, so let's unpack this for everyone listening.
Well, the persistence on display in this record really highlights a fundamental tension we have in our justice system.
Yeah.
Because courts require finality to function, right? Otherwise, we'd just be locked in this endless loop of relitigation.
Nobody wants that.
Exactly. But courts also have a mandate to seek the truth. And when those two priorities collide, like when a finalized judgment is suddenly challenged by newly unearthed contradictory evidence, the procedural hurdles you have to clear are they're astronomically high.
So let's lay out the factual foundation of this dispute for you, because the divergence in the narratives here is just staggering. It starts at a construction site.
Right, as these labor law cases often do.
Yeah. And initially, the contemporaneous documentation paints a very specific, very contained picture. You have the on-site incident report, the medics report, the initial medical provider records.
All from right after it happened.
Right. And they all document the plaintiff stating that a crowbar slipped and struck his right finger.
Just a finger.
Just a finger. It's a minor, discrete injury. But then the timeline shifts.
It shifts drastically. Over a week later, the plaintiff retains the law office of Lawrence Biondi. And that firm refers him to a specific doctor, a Dr. Colon.
And this is where the story just completely transforms, doesn't it?
Oh, entirely. It goes from, a dropped crowbar hitting a finger to this wild claim that the plaintiff was subjected to a 10-foot suspended swing from his safety harness.
Wow.
Yeah, allegedly causing multiple parts of his body to repeatedly crash into the walls of the work area.
I mean, that is not a slight exaggeration. That is an entirely different universe of physics. A dropped tool versus a catastrophic structural swing.
It's night and day.
And the defense isn't just calling this a harmless discrepancy. They are explicitly alleging in their filings that this is part of a deliberate pattern. They call it a mill.
Right, they use that exact word.
Yeah, a system designed to escalate minor injuries into massive payouts. They allege this transformation paves the way for a whole potpourri of unnecessary spinal fusions and whole-body orthopedic surgeries.
Just to juice up the case value.
Exactly. Feeding into third-party litigation, funding TPLF and lean care, factoring profits, the whole thing. They are even raising third-party fraud allegations against the plaintiff's treating physicians.
Including Dr. Marola, I believe.
Right, Dr. Marola. Now, we should make it very clear to everyone listening that these are the defense's allegations regarding the broader ecosystem of the claim. We're just impartially reporting what is in the filings.
Right, absolutely. But those allegations really provide the crucial context for why this specific legal battle was fought so viciously. I mean, the financial stakes of a 10-foot suspended swing claim are exponentially higher than a crushed finger.
Oh, for sure. Millions of dollars higher.
Exactly. And this massive shift in the fact pattern is what allowed the plaintiff's counsel to move for summary judgment under Labor Law Section 241.
Okay, let's break that down. For those of you operating in or around New York real estate and construction, labor law 241 is basically the heavy artillery.
It's the scaffold law.
Right. It deals specifically with elevation-related risks.
And the distinction between 241 and the neighboring statute 241-6 is really the hinge upon which this entire case swung initially.
How so?
Well, Section 241-6 deals with specific industrial code violations and allows for comparative negligence. So if a worker is partially at fault for their injury under 241-6, the damages can be reduced.
Okay, makes sense.
But Section 241 imposes strict liability on contractors and owners for gravity-related hazards. If you fail to provide proper fall protection and a worker is injured as a result of gravity, liability is almost absolute.
So by inventing, or rather introducing this new narrative of a 10-foot suspended swing, it placed the accident squarely in the highly lucrative jurisdiction of 241.
Precisely.
But my immediate question when reading the case file was, how did the plaintiff manage to win that summary judgment in the first place?
Right, given the conflicting reports.
Yeah. The initial on-site medic reports explicitly stated it was just a crowbar injury. Normally, a contradiction like that creates a tribal issue of fact, which automatically defeats a motion for summary judgment.
You'd think so. But the plaintiff executed a very effective evidentiary block. They argued that the benign, contemporaneous versions of the accident, the ones mentioning the crowbar, were based on a mistranslation. Because the plaintiff is a non-English speaker, and an unknown individual translated his initial statements to the medic.
So they blamed the translator.
Exactly. The plaintiff's legal team successfully convinced the motion court, and subsequently the appellate division, that because the translator was unidentified and unverified, those initial medical reports were inadmissible hearsay.
Wow. So they successfully barred the crowbar story from the courtroom entirely.
Completely threw it out.
And with the medic report disqualified, the only admissible narrative left standing was the 10-foot suspended swing.
Right. So the court grants partial summary judgment for the plaintiff.
And the First Department affirms it.
The concrete is poured.
So how do you get out of that? I mean, what is the legal mechanic for reopening something so finalized?
It's called a post-appeal renewal. And overturning a summary judgment after the appellate court has affirmed it, it requires meeting a standard that the court explicitly describes as a heavy burden.
Heavy is probably an understatement.
Oh, absolutely. The defense, who was represented at the appellate level by Kahanafeld partners Sofia Vadoff and Christina Pingaro, they had to navigate precedents like the matter of Weinberg and Tishman.
The matter of Weinberg is fascinating to me because it essentially establishes that you cannot simply ask for a do-over just because you came up with a better legal argument in the shower.
Right. No light bulb moments allowed.
A post-appeal renewal demands that the moving party prove the crucial facts they are introducing actually existed at the time of the original motion. They had to be extant.
You are strictly prohibited from manufacturing new evidence post-judgment. But Weinberg and Tishman add a second, much steeper requirement. You have to prove it was utterly impossible for you to obtain those extant facts earlier, even while exercising maximum due diligence. A key threshold in this timeline is the concept of perfecting an appeal.
Let's break down what perfecting actually means in this context, because it's not just a casual term, right?
No, not at all. In New York appellate practice, perfecting an appeal is the formal process of finalizing the record and submitting the briefs to the appellate court.
So you're locking in the evidence.
Exactly. You are assembling the immutable universe of documents, transcripts, and evidence that the appellate judges will review. Once an appeal is perfected, that universe is essentially sealed.
Okay, so the defense here had to show the court that they were actively, aggressively trying to find this new information before that universe was locked, but they simply couldn't.
Right.
It's basically the legal equivalent of a sports team demanding to replay the final quarter of a championship game years after the trophy has already been engraved.
That's a great analogy.
Because they're arguing, hey, we just found a new camera angle of a disputed play. In any normal scenario, the commissioner just laughs them out of the room. The system demands finality.
But the New York courts have left this tiny, incredibly narrow window open to prioritize truth over procedural bureaucracy, provided you can prove you weren't sleeping on the job.
Which brings us to the actual legwork, proving that diligence falls heavily on the defense's timeline. So the defense originally submitted their opposition to the plaintiff's motion for summary judgment way back in 2022.
Right.
And it wasn't until the end of 2024, 2 full years later, that defense counsel Stephen DeSouza of Abrams-Gorlick successfully identified the non-party translator.
2 years of hunting for an unnamed individual in New York City who happened to translate a conversation at a construction site.
It's literally a needle in a haystack. The legwork involved in tracking down that one specific person is staggering. Great doggedness and detail-oriented work by the defense counsel there.
Absolutely. And finding him was really just the initial hurdle. The timeline accepted by the court shows that even after identifying this translator, a man named Rafael Silva, at the end of 2024.
He didn't even agree to cooperate immediately, did he?
No. He didn't agree to cooperate with the defense until April of 2025. Securing cooperation from a non-party witness years after an event is notoriously difficult.
So he finally agrees. Then what?
Silva finally signed his official affirmation, his sworn statement detailing his memory of the translation, on June 30th, 2025. And the defense filed their motion to renew approximately 1 week later.
Wow. That 1 week turnaround is the key to passing the Tishman test, isn't it?
Yes, exactly. It proves to the court that the moment the impossible-to-obtain evidence became available, the defense acted with immediate urgency. There was no strategic delay whatsoever.
But the plaintiff didn't just give up. They attempted to weaponize this timeline against the defense.
It did. And the appellate ruling reveals a really critical detail here. During his own deposition, the plaintiff was completely unable to identify who had translated for him.
I mean, think about that for a second. The plaintiff didn't know who translated his own statements about his own accident.
Right. And based on that failure, the plaintiff actually filed a cross motion to completely preclude Silva's testimony.
Wait, their argument basically boiled down to, we couldn't identify him, so you shouldn't be allowed to use him now that you've done the work to find him.
That was the argument.
That is such a bold maneuver, trying to use your own inability to identify a witness as a shield to block the opposing counsel from introducing him.
It didn't work, though. Trial Judge Paul A. Goetz denied that cross motion, and the First Department affirmed his decision. They cited a precedent known as Scherer.
Okay, what does Scherer say?
Under Scherer, the appellate court ruled that because the plaintiff was unable to identify the translator at deposition, it was an appropriate exercise of discretion by the trial judge to allow the defense to introduce Silva once they tracked him down through their own independent investigation.
So the court effectively rewarded the defense's shoe leather investigating. They turned an adverse summary judgment ruling into a renewed opportunity to defend the case on the merits.
Yes, excellent team effort by the defense.
Which brings us to the actual content of Rafael Silva's affirmation. Because, let's be real, finding a missing translator only matters if the translation completely alters the established narrative.
Oh, and it did. Silva's sworn statement definitively declared that while translating for the plaintiff immediately following the incident, the plaintiff never once mentioned a fall or a suspended swing.
Never mentioned it at all.
Not once. According to Silva, the plaintiff stated exclusively that a crowbar had struck his finger.
Boom. This is the smoking gun that shatters the poured concrete of the summary judgment.
Exactly. But introducing this statement into evidence requires overcoming the exact same hearsay hurdle that the plaintiff used to win the case in the first place.
Right, because you have a third party repeating what someone else said out of court. That's textbook hearsay.
Yes. So the defense bypassed the hearsay rule by utilizing the agency exception. They relied on a precedent called Navarrete.
I love the mechanics of this exception. It essentially treats a translator like a clear pane of glass. If you can prove the glass is perfectly clean, meaning, the translator is competent and objective, then the words pass right through without distortion.
That analogy captures the legal mechanism perfectly. Under Navarrete, if a translator is demonstrated to be competent and objective, they are legally acting as an agent of the speaker.
So it's not hearsay anymore.
No, it's considered a direct representation of the speaker's own words. It becomes an admission by a party opponent, making it fully admissible in court.
And the appellate partners, Uvedov and Pingaro, they successfully established that Silva was that clear pane of glass.
Right, he was just an objective third party.
So suddenly, the court is presented with admissible sworn testimony from the plaintiff's own translator that directly contradicts the foundational premise of the entire Labor Law 241 lawsuit.
And the legal impact of this contradiction really hinges on the concept of proximate cause. The First Department cited the Campos and Bezderek precedents to explain this part.
Proximate cause, meaning the direct chain of events.
Exactly. A statutory violation under 241, like a failure to provide adequate fall protection, does not automatically create liability in a vacuum. There must be a mechanical causal link between the safety failure and the actual injuries sustained.
Right. Like even if a construction site is wildly unsafe and lacks every harness mandated by law, if you drop a hammer on your own toe, the lack of a harness isn't the proximate cause of your broken toe.
That's a perfect example. And the Campos and Bezderek precedents establish that if the mechanism of injury is genuinely disputed, summary judgment is impossible.
Because it's up to a jury now.
Yes. By introducing Silva's testimony that the injury was caused by a slipping crowbar, the defense completely decoupled the plaintiff's injury from any elevation-related hazard. If he didn't fall, the presence or absence of fall protection is legally irrelevant to his specific injury.
This creates what the court calls a triable issue of fact. You can no longer declare, as a matter of law, that the defense is strictly liable under the scaffold law. A jury actually needs to look at this and decide, did the guy fall from a 10-foot swing or did he hit his hand with a tool?
And just like that, the foundation of the summary judgment evaporated.
It's amazing.
The trial court officially granted the motion for leave to renew, and upon renewal, vacated and denied the plaintiff's motion for partial summary judgment.
And the First Department unanimously affirmed it. It really validates all that exhaustive investigative work performed by the defense.
It was a tortured path to 100% justice, but they eventually got there.
It is a remarkable journey. A summary judgment is won, it's blessed by the appellate court, and seemingly locked away forever. Yet because defense counsel Stephen DeSouza spent 2 years hunting for a needle in a haystack.
And because appellate partners Uvidov and Pingaro expertly navigated the Weinberg, Tishman, and Alvarez precedents to get that needle admitted into evidence.
So the entire affirmed judgment is dismantled.
Observing how the defense systematically utilized those precedents provides a real blueprint for attacking seemingly insurmountable procedural barriers. They didn't just argue the facts were wrong, they proved the actual process of how those facts were originally established was flawed due to the missing translator.
It's a huge lesson.
It is. This case serves as a powerful testament to the necessity of verifying primary sources. We frequently accept the finalized top-line summary of an event as absolute truth. But this decision reveals that the official record can be entirely rewritten by going back to the point of origin and locating the objective individuals who were actually in the room.
It really forces you to look at the phrase settled law with a healthy dose of skepticism. The defense's allegations regarding a mill inflating these claims, combined with their success in uncovering this translation discrepancy, well, it leaves us with a provocative thought for you to ponder. If a single objective translator's memory tracked down years after the fact can completely erase a judgment that had already been stamped and approved by the appellate division, it makes you wonder how many other heavily funded, legally settled cases out there are currently resting entirely on unverified translations and early narratives that have never been subjected to the scrutiny of a neutral third party.
It's a sobering thought.
It is. Keep digging, and we will catch you on the next deep dive.